Lordship will be permitted to mention one matter for inclusion restoration application.
Application monthly list January.
It is a MSK matter.
Application monthly list January.
Grateful Lordship.
Yes. Yes.
I don't want that happen. आवाज से बोलते
Chalo. Dini.
The last location,
What is the matter about?
well, it is an application for contempt. My Lordship has been pleased to pass an order on 18th May 2022 directing some compliance to be made by the respondent Punjab National Bank and its officials. My Lordship will find the order at page 107. But a fixed deposit was for a particular period was kept and lying with the respondent bank by the petitioner state cooperative bank, my lord. And on the maturity, my lord, they had, my lord, said, my lord, there was a forgery on the part of the third party
Then
transaction.
what happened?
Thereafter, my lord had been pleased to adjudicate the matter, and my lord had been found that the entire amount with interest is payable from the respondent to the petitioner bank. My lordship, kindly come at page one.
Both are bank. Both are bank.
Both are bank. One is State Cooperative Bank and the second is the Punjab National Bank. Order was on the Punjab National Bank, my lord.
Then what happened?
My lord, thereafter, my lord, and as per the order, we were supposed to communicate the order. We have duly communicated the order. Thereafter, my lord, they did nothing, my lord. They did not respond, my lord. They had gone a file and appeal, and thereafter spontaneous adjournment was sought for and taken before the court presided over by Honorable Chief Justice. Honorable Chief Justice, by an order, then specifically directed that with a liberty to the respondent petitioner bank, my lord, to proceed in contempt if my lord, that order, my lord, kindly, but kindly come to 140. That order, my lord, may I start with. And Lordship, the continuous adjournment that has been taken are at page 141 to 148. All the orders I have annexed.
Adjournment page 142.
141 to 150. Liberty is a 140.
140.
140, my lord.
142.
140, my lord, the liberty given by Honorable Chief Justice. And my lord, 141 to 148 are the pages of order wherein continuous adjournment has been taken before the appeal court without any compliances. No interim order, no stay, and the liberty is there.
Last order.
My lord,
The appeal court.
my lord, the 5-1, this one at page 140. This is the last order, my lord. Is January 5, 2023, my lord.
Adjournment starts from 148.
My lord, 141. 141.
148.
148, my then.
Then what happened?
And my lord, we have in compliance to your lordship's direction, my lord, lordship will find at page 149. We have, my lord, communicated the order in terms of your lordship's order, but we have communicated to the respondent bank, my lord. And thereafter, my lord. Yes, yes.
Show me the direction.
My lord, kindly come at page directly, my lord, come at page 138. But the order starts at page 107, my lord. Internal page 32.
Yes.
My lord, may I read out, my lord? That will be portion. Paragraph 52, my lord, in view of the foregoing discussion and reasons, I am of the firm opinion that the first respondent has illegally, wrongfully, and arbitrarily withheld the same matured term deposit proceed of the first petitioner. This was purely a commercial transaction between the parties.
Was this judgment, was it reported somewhere?
Well, in SCC online it is, and Malad, since I have asked the AIR is about to report, Malad.
No, because somewhere I have seen this.
Yes, Malad.
আচ্ছা শুনুন, ওই যে বড় দুটো জাজমেন্ট হয়েছে না, একটা আপনাদের তিনজনের হাতে আর একটা বোধহয় বাসুদেব বাবুর হাতে। ওটাও আপনাদের। ওই দুটো সার্ভার হওয়ার পর আমার সার্ভার প্রিন্ট আউট দেবেন, সার্ভার প্রিন্ট আউট, আর দুটোই আজকে সার্ভার করে দেবেন। একটা তো কাল আমি পাঠিয়ে দিয়েছি সই করে, আর একটা বড়টা আজকে দেবেন, আমি করে সার্ভার।
The first respondent should pay interest upon the said mature term deposit proceed to the petitioner for such wrongful withholding. Contemporaneously, when the fixed deposit was created and was matured, and immediately thereafter, the rate of interest was much higher than what is prevailing now. Balancing the equity between the parties, this court directs the first respondent to pay a simple interest of at the rate of 5% per annum since January 25, 2016 on the said matured value of rupees 26 crore 35 lakhs 18,454 and 93 paisa till the day the said entire proceed with interest as directed herein would be tendered to the first petitioner and not thereafter. In the
Very
important, this is there was a direction of compliance on our part. The first respondent must tender and carry out the entire exercise as directed above for return of the said sum of rupees so and so together with interest as directed above to the first petitioner within a period of 6 weeks from the date of communication of a server copy of this judgment and ordered to the Selimpur branch of the first respondent and or to any other appropriate order. This order, but we have duly complied. Lordship will find at page 149. Nonetheless, my lord, they were able because with that very order,
What was your part of compliance?
and we were supposed to communicate them the
That's
we have.
এটা আছে
ওটা তো আমরা appeal করেছি।
2022 SCC অনলাইন।
এই যে my lord, হ্যাঁ।
Who are the contemners?
My lord, the Punjab National Bank, my lord, the senior manager, my lord, here, my lord, and also the Lordship will find, my lord. I've made them party, my lord.
Page 7.
Page 7, Lordship will find Mr. K.G. Anantha Krishnan, the chairman, Punjab National Bank. Then by the Atul Kumar Goel, the CEO, managing director, and by the Shantanu Sen, who is the branch manager here. And one Upal Shah, the senior manager here.
Very well.
My lord, that is reported in 2000, Lordship's judgment that is reported in 2022 SCC online, Calcutta 1280.
No, I have seen somewhere, perhaps I may be wrong, that's some journal. I don't know. I may be wrong.
AIR personally told me that they are going to report it, not as AIR online.
No, whatever. As I'm aging, I can't read. I've seen somewhere. Where? This is a content proceeding arising from the judgment and order dated May 18, 2022, passed by this court. Annexure C at page 107 to the contempt application. Communication, show me.
Page 149, my lord.
The petitioner has communicated the order by its letter dated May 19, 2022.
বলেছি বলেছি
Where is the receipt?
মানে page 151
That's the dispatch.
মানে
Annexure F at page 149 to the writ petition. High contempt application.
সেটা জানেন তো স্যার ফিল করেছে
The respondent Punjab National Bank in the writ petition preferred an appeal, being FMA 812 of 2022. Poster. The series of orders passed by the Honorable Appellate Court since November 23, 2022 till January 6, 2023. Annexure D at page 142 to 148 of the contempt application.
January 5
So January 5, 2023. Annexure D at pages 140 to 148 of the contempt application.
Orders passed by Honorable since January 5, 2023, and it should be at pages 148 of the content
Would show that the Punjab National Bank appellant either obtained adjournment or avoided to proceed with the appeal. Paragraph. The last order of the series passed by the Honorable Appellate Court dated January 5, 2023 contained the following observation of the Honorable Appellate Court. Quote from page 140. Quote 1. Poster. The contempt application was filed on May 10, 2023. Order was dated
মানে order was dated মানে 18th May 2022
content file 10th May, within 1 year. Poster. In view of the above, for the time being, it will be issued. There shall be a rule issued to be issued. There shall be a rule to be the rule upon alleged container numbers 3 and 4. You will achieve of the above.
time being, there shall be upon the alleged container numbers 3 and 4.
There shall be a rule to be issued upon alleged container number 3 and 4. Full stop. Paragraph. The department is directed to draw up, complete, and serve the rule at the earliest. Full stop. The rule is made returnable on January 19, 2024. Full stop. It is made clear that this order shall not be construed that the alleged container number 1 and 2 stands exempted from serving a rule upon them, for issuing a rule upon them, comma, in the event this court thinks it fit in future, in the event that this court thinks it fit on the next day, upon further consideration of the content application, comma, this court may consider to issue rule upon respondent number 1 and 2. Alleged container numbers 1 and 2. Paragraph. The proceeding shall appear under the heading content application on with date কি বললাম? January 19, 2024. ওই প্যারাগ্রাফটা কি বলেছে যেটা এখন বাদ দিলাম, পড়ুন লাস্ট দুটো প্যারাগ্রাফ। প্যারাগ্রাফ এটা, হ্যাঁ প্যারাগ্রাফ, হ্যাঁ ডেটটা বোল্ড, তারপর
that the alleged container numbers 1 and 2 stand exempted from issuing scope makes it fit on the next day upon further consideration of the application. This scope may consider to issue upon the alleged container numbers 1 and 2. Selection.
Major objection upon us to serve this order upon respondent 1 and 2.
What is the law?
Should be upon the alleged containers.
What is the law after I issue the rule? No, consider the law. Department cannot be, because correctly told by my officer, since the appeal is pending, it's before the appeal court.
Well, as a
It file is not necessary, it is merely for reference.
yes, on the last occasion, Lordship has been pleased to indicate that also. But since that was written in the.
If I find any ambiguity or look into it, then I will call for it.
Even the read has been annexed in the petition also. Grateful.
Number 2.
আচ্ছা আরেকটা লিখে দিন, last line. However, pendency of this content application shall not preclude the alleged containers to carry out the direction of this court in total compliance of it. Dated May
18, 22.
date of the order.
May 18, 2022.
2022. এতগুলো হাই স্টেট তো প্যারাগ্রাফটা থাকলে
My lord, I have alleged contempt. I have fulfilled my promise and I have complied your lordship's
Complied
order. Full,
Fully go.
enter.
Any report?
Yes, the report, my lord, amount has been, my lord,
Amount has been credited.
No, if you want to place anything on record,
my lord, only for that the payment has been
I
made.
don't mind, sir. Come on, Ashu. So long, I believe in solution.
My lord,
Solution
Well-
comes, matter ends.
my lord.
This is a content proceeding arising from the order passed by this court dated
My lord, order dated
January 3, 2023.
January 20.
Full stop.
No.
Previously, paragraph. On several occasions, the content proceeding was considered by this court and orders were passed from time to time. Paragraph. Mr. Shubhranshu Panda, learned counsel, appearing for the alleged contemners, submit that the order of this court dated January 3, 2023 stands totally compliant. Full stop. Paragraph. Mr.
Phalguni Bandyopadhyay.
Phalguni Bandyopadhyay, learned advocate appearing for the petitioner, has also confirmed the submission of Mr. Panda. Paragraph. In view of the above, nothing further survives in this content proceeding. Full stop. Paragraph. This content proceeding, CPAN 803 of 2023, stands dropped and closed. Paragraph. The content application CPAN, যদিও এটা আমার লিখতে মানে বাদে, এটা ভুল লিখি আমরা, কিন্তু আপনার সিএসআই নাকি কম্পিউটার তো নেবে না, আমায় বলে দিয়ে গেছে, শুধু ড্রপ লিখছে। CPAN 803 of 2023 stands disposed of.
Deeply obliged to your lordship.
I'm good.
Thank you.
And my lord, I am grateful, lordship, because your lordship has trusted me and I have complied with your lordship, my lord.
Why not?
My lord,
Sir, at the end of the day, you are the officer of the court.
deeply obliged.
Absolutely.
Well.
If the court doesn't bank on its own officers, upon whom it will bank?
My lord, deeply obliged.
And I will always trust. I get full cooperation from the
Well.
bar. Full cooperation.
Well.
Mr. Mukherjee is smiling.
Correct. But item 3, for the alleged contemner,
Right.
order has been complied with. I have
Order
passed
has
the-
not been complied with. I may join.
One second, 1 minute.
I'm
I
sorry.
will hear you. Would you file any compliance this matter?
The region order, lordship was directed to pass a region order. I have passed a region order.
Has he got it?
I have got.
Have you got a copy?
Yes, I have got it, but there was further directions which have not been complied.
What is that?
My lord, there was a direction I'm just reading out. In the event the reasoned order goes in favor of the petitioner, then the respondent number 2, which is the contemner herein, and 5 shall take all necessary and consequential steps in favor of the petitioner positively within a period of 4 weeks from the date of communication of the reasoned order to the respondent number 5.
That part is
That part is not
1
complied.
second. Reasoned order goes in your favor.
Reasoned order is in my favor.
Very.
That was communicated. I'm sorry.
Oh,
I'm sorry.
wait, hold your breath.
I'm sorry.
Mr. Panda, when shall I keep it?
After vacation, my lord.
Give me a date. Any Friday you consult, both of
Yes.
you consult, give me a date. Ashu. This is the content proceeding arising from an order of this court dated January 3, 2023. Paragraph. In part compliance, no, sorry. In compliance of the said direction of this court, a reasoned order has already been passed, dated
My lord, dated 14th March 2023.
March
Communicated. I'm sorry.
March 14, 2023. A copy of the same handed over by Mr. Shubhranshu Panda, appearing for the alleged contemners, is taken on record. Full stop. Paragraph. Mr. Shaunak Ghosh, Learned Counsel for the petitioner, submits that the order dated January 3, 2023 had two parts. The first part directing to pass a reasoned order. The second part, if the reasoned order goes in favor of the writ petitioner, well, then to give effect thereto within a specified time frame. Mr. Ghosh submits that the reasoned order has gone in favor of the writ petitioner. Therefore, the first part stood compliant. However, since the effect has not yet been given, the second part has not yet been completed. Paragraph. On the prayer of Mr. Panda, give me a date. You agree? Both of you on Friday? On the prayer of Mr. Panda, for compliance of the said second part, some time is granted, and the matter shall appear under the heading contempt application on
my humble submission, can it be fixed, my lord, 2nd February? 2nd February?
If it can be on
26 is, my lord,
January, any Friday on
my lord,
26
holiday.
January is a holiday, but
here member, naturally
Very well.
the steam is much.
any
Certain. Give me a date.
Very well. 19 January.
January 19, 2023. 24. For compliance, for total compliance of the direction.
Right.
Naturally, the steam is much.
Deeply.
Deeply.
For
Oh, my lord, I'm for the petitioner, my lord.
This is my,
No.
I am for the alleged
6th
contempt.
October, my lord, directed to file an affidavit on behalf of the, file an affidavit to the, and opposition, I have received the opposition on yesterday, my lord.
Contempt.
Opposition,
My lord, in contempt proceedings, my
Contempt
lord,
proceedings.
I,
One second.
in a contempt proceeding, my
Direction carried out or not?
my lord, I carried out, my lord, earlier, my lord, first date, I respectfully submitted to your lordship that there is no contempt because the order has been complied with. They have, my lord, disputed. That is why my lord was pleased to direct me to file affidavit in opposition. This is my affidavit in opposition. There is no contempt.
I will see to that.
yes, yes, yes.
You wish to file reply.
Yes, my lord. I've just received on yesterday, my lord.
Yes.
Ashun,
It will be appear after vaccination.
on the prayer of Mr. Arindam Chattopadhyay, Learned Counsel, appearing for the alleged, how many?
One.
Contempt now. Time to file affidavit in opposition. Stands extended till today, full stop. The affidavit in opposition affirmed on December 7, 2023, filed in court today is taken on record, full stop. Copy has already been served upon the petitioner, full stop. Paragraph. The petitioner shall be at liberty. Copy has already been served upon the petitioner on yesterday. As this court has been informed. Full stop. Paragraph. The petitioner shall file affidavit in reply on or before. Give me
January, my lord.
31st January. Give me a date.
1st week of January.
Give me a date.
6th.
January 6, 2024. January 9, 2024. Full stop. The contempt proceeding shall appear. The proceeding shall appear under the heading contempt application on January 19. January 19, 2023. 24.
24.
আসুন। এটা রেখে দিন, এটা অপোজিশনটা কি ফেরা। নেক্সট।
I'm applying for the petition. That ultimately it has not been served.
No, it is
The
the first time this
department-
matter is appearing.
No, my lord. From the commissioner's part, my lord, I have instruction to appear, and since, my lord, the reason order has already been passed.
I have not been communicated, my lord.
Has it gone in his favor?
My lord, yes, ma'am.
So carry out.
Already been allowed from the commissioner of school education.
Very well. You have not been served with the result
Not
order.
served, nothing.
Right. What's your name?
Shobboshachi Mondol. Shobboshachi Mondol.
Mr. Shobboshachi Mundo. This is a content proceeding arising from the order passed by this court on
27th of March 2023.
March 27, 2023.
Hearing,
Full
Or-
stop. Mr. Shumon De, how many containers?
yeah, got 50.
One.
One.
Mr. Shumon De, learned counsel appearing for the alleged container number 1, submits that the reasoned order
In compliance, your lordship, sorry.
has already
Milord.
been passed.
Lordship, may I indicate one thing? No, I'm
Reasoned order has already been passed. Full stop.
Milord.
Paragraph, Mr. Shobboshachi Mundol, learned counsel for the petitioner, submits that no copy of the reasoned order has been furnished to the petitioner. Paragraph. Today in court, Mr. Shumon De
Mhm.
has made over a copy of the reasoned order to the learned counsel for the petitioner, and the copy has been submitted before this court, which is taken on record. Full stop. Paragraph. Mr. De further submits that if any further compliance is required to be carried out in terms of the direction of this court, the same shall be done in the meantime, if not done already. Full stop. Paragraph. The petitioner shall also take instruction from the learned counsel for the petitioner shall also take instruction from his client in this regard. Full stop. Paragraph, the proceeding shall appear under the heading content application on January 12, 2024.
Lord, may I stand corrected on the Lord? There are 3 containers. I begging pardon, your lordship.
Containers,
3 containers.
alleged containers.
3 containers. Lord, your lordship has direct.
One day containers.
Lord, in the paragraph, your lordship has stated, as per my submission,
12 রাখা যাবে না তো। 12 January it cannot be kept. 19th,
19.
12th cannot be kept.
Yes.
19th. Any
দিদি একটা জায়গায় ডাইরেকশন 1 কন্টেইনার লেখা ছোট একটু কাইন্ডলি ঠিক করে দেবেন গেটফুল টু লর্ডশিপ
he is even more experienced than me.
this is my fault, my lord. I could not assist your lordship properly.
He is experienced than many of us.
হ্যাঁ কপি দাও ও এটা দিয়ে দিচ্ছি চলো গেটফুল টু লর্ডশিপ
Next,
6 more, I have heard the contemner. Mr. Bidhan Vishwas is appearing for the petitioner. He last night, my lord, he called me and said that due to his son's illness, he is unable to come. So, my lord, kindly fix this matter after.
the learned counsel for the petitioner has not been able to attend court today due to the illness in his family, due to some serious illness in his family, comma, as this court has been informed. Full stop. Paragraph. Mr. Sarwar Jahan, learned counsel, appears for the alleged contemners.
Contemner.
One.
One.
Contemner. In view of the above, the proceeding compliant, direction
No, my lord, we were granted liberty to use opposition, my lord.
Okay.
That is ready.
So opposition you have filed,
Ready, my lord, I shall file the next day.
expedite. Full stop. কি বললাম? না, কাটুন। Mr. Jahan, learned counsel, in his usual fairness, submits that he shall be praying for an extension to file the affidavit in opposition as directed by this court previously. Paragraph. Time to file affidavit in opposition stands peremptorily extended. Tell me.
Next week.
Yeah, date.
till 24th. Sorry,
December.
22nd.
January 3, 2023. January 3, 20 কি বলছি আগে শুনুন January 3, 2024 paragraph affidavit in reply if any thereto shall be filed by January 15, 2024. Stop. Paragraph, the proceeding shall appear under the heading contempt application on January 19, 2024.
Great month.
Next.
My lord, I am appearing for the petitioner. Yesterday, I have received the reason order,
So compliant.
though it's complied, but not in my favor, my lord.
So what? Who said that it will have to be in your favor?
No, that's my lord. Kindly see the second paragraph.
If show me the direction of the court, then of course a contempt that it has to.
Lordship, kindly see the second paragraph of the recent order.
Mr. What is your name?
Shahid Uddin Ahmed.
Sorry?
Shahid Uddin Ahmed.
বুঝতে পারছি না
Sahid Uddin Ahmed.
Sahid Uddin Ahmed.
SAHIDUDDIN.
Sahid Uddin Ahmed, learned advocate, appears for the petitioner on virtual mode. Paragraph. Mr. Prosenjit Mukherjee, how many containers?
Only one. Secretary of the West Bengal Madrasa.
Prosenjit Mukherjee, learned counsel, appears for the alleged contemner. Paragraph. Today, Mr. Mukherjee, by way of an affidavit, affirmed on December 13, 2023, has filed the compliance report showing that the reasoned order has already been passed as directed by this court. In total compliance of the direction. Paragraph. The affidavit, compliance affidavit is taken on record. Paragraph. Learned counsel for the petitioner submits that has also confirmed the compliance of the direction of this court to the extent that the reasoned order has already been passed. Paragraph. In view of the above, this is a content proceeding arising from an order of this court dated. This court, Mr. Mukherjee?
Lordship.
Yes.
December 20, 2022. আচ্ছা শুনুন অন্য কোনো জজ সাহেবের কন্টেন্ট কিন্তু আর আমার ডিটারমিনেশন নেই বেরিয়ে গেছে পোস্ট অফ তারপরে যা লিখলাম in view of the above nothing further survives in this content proceeding. Paragraph. Accordingly CPAN 1386 of 2020 stands dropped and closed. Paragraph. The content application bold CPAN 1386 of 2023 stands disposed of.
Also, may I hand over the original copy of the reason?
Original copy of the
Reason order.
Why? You should keep it in your file. You have given a copy here.
Yes.
Copy.
And this is the original.
Copy here.
Yes. And
Sufficient. You keep it in your own file. Because you have to furnish them, not to the court.
Grateful.
Thank you.
Yes, ma'am. I'm for the state, madam.
I'm for the petitioner, my lord. My lord, the order has partly complied with, my lord.
Why? Show me the order.
The brief is not with me, my lord. The DRP schools reported the vacancy before the service commission, my lord. Thereafter, the school service commission
Well, Mr. Supriyo Chattopadhyay appearing
Yes.
this matter. His absent
Have the
duty is mother
instruction-
release. His mother has been hospitalized.
On
First
the-
thing.
on the-
Second
on
thing,
the-
my lord, the order has been totally compliant.
no, totally not compliant.
Very well. or on the prayer of Mr.
Sheikh Imtiazuddin.
on the prayer of Sheikh Imtiazuddin, learned advocate for the petitioner, the content proceeding shall appear under the heading content application on January 19,
But next week, my lord, partially complied with.
No,
No, my lord, fully
January
compliant.
19, 2024. Next week is the last day. So January 19, 2024, post a paragraph. It is made clear that pendency of this content proceeding shall not preclude the alleged contemner, single or multiple,
Single.
contemner, to comply with the direction of this court totally, comma, if not complied in the meantime.
Yes.
Full stop. আর মাথার উপর লিখুন, this is a content proceeding arising from the order of this court dated. দেখি দিন, কেউই দুজনে কেউই ব্রিফ আনবেন, অদ্ভুত। চিন্তা করতে পারতাম না আমরা, কন্টেন্ট মুভ করছে, ব্রিফ নেই হাতে, জুনিয়র। January 11, 2023.
Deeply.
Very sorry affair. Very sorry affair. নাইন কি হলো? ফাইল নট হিয়ার, কেন? কেন? ঝিমিয়ে ঝিমিয়ে চললে হবে না, কন্টেন্ট এরকম ঝিমিয়ে চলে। আপনারা একটা অথরিটি এক্সাক্ট করুন। শুনুন, এদিকে আসুন। আপনি আপনার অথরিটিটা এক্সেপ্ট করবেন না, বলেন আপনি যদি কন্টেন্ট না ফাইল পাঠান, মাইনর স্পেসিফিক ইনস্ট্রাকশন দিয়ে দিয়েছেন, কিন্তু একদম বলে দেবেন, ঠিক আছে? এদিকে দেখুন, বলে দেবেন। নেক্সট, সরি, ফাইল নট হিয়ার। ইয়েস, নেক্সট।
I'm for the petitioner.
Which one?
Item 10.
Yes, madam.
This is a matter of transfer of single subject teacher.
1 minute, 1 minute.
This is a matter of contempt application.
Oh, yes. From
The,
my order.
yes,
First time.
yes.
Show me the order.
Page 19. In the order,
1 second. Let me see. Yes, madam. What's the direction? Kindly take me to the direction.
in page 20, paragraph number 2, the Lordship directed to conduct a hearing, and as per the hearing has been duly conducted. As per the hearing, after that, in page 21,
Read it from 20. In view of the above, the respondent number 2
while
shall
taking
take
a
a
decision,
reasoned decision in the light of the content of the document dated such and such in terms of the claim for transfer made by the petitioner. This was done.
yes,
Decision taken.
reasoned order has been passed.
All right, 1 second. While taking decision, the respondent number 2 shall serve at least 7 days prior hearing notice, blah, blah, blah. Acha. It is made clear that while taking a decision on the issue, the respondent 2 must bear in mind the pupil-teacher ratio for both the schools. Okay, it is made clear that this order shall not create any. Yes, what is the? Show me the reasoned order.
The reasoned order in page 23, in the last paragraph, that taking into the account the facts as stated in points 1 to 11 above with the particular reference to point 9 to 10 therein, I am of the opinion that the academic interest of the students of Bandhabhushan Junior High School, Purva Mednipur should not be compromised even if the transfer application of Sri Sujit Paik is allowed. In view of the commitment shown by Gautam Singh, assistant teacher, Nayaput Sudhir Kumar Singh High School, Purva Mednipur, as stated in point numbers 8 to 9 above. Hence, I am of the opinion that the transfer application of Sri Sujit Paik may be processed as and when the temporary suspension of the transfer portal Utsosri is withdrawn by the school education department, Sri Sujit Paik. The
Where is
petition,
the content, madam?
the contempt in the in your lordship order in page 3, that in the event of the recent order goes in the favor of the petitioner, the respondent number 2, the chairman, West Bengal Central School Service Commission, shall take all necessary and consequential steps to give effect to the recent order forthwith.
So recent order has gone in your favor.
Yes,
In your favor. He has not taken that step.
yes.
That's right. To effect the transfer. Yes.
A notice may be served upon us so that the complaints report.
Notice will be served through the department. Don't worry. কি বললাম? This is a content proceeding arising from an order dated annexure P1, order dated May 16, 2023. Annexure P1 at page 19 to the writ petitions. Full stop. The order has its two parts. The first part is was the direction for passing a reasoned order, and the second part, that if the reasoned order goes in favor of the petitioner, then the alleged contemner to take steps, all consequential steps to give effect thereto. Paragraph. Pursuant to the said direction, the reasoned order was passed on November 23, 2023. Annexure P2 at page 22 to the content application. আগেরটা লিখেছেন annexure P1 orderটা. Thank you. Poster. Read that transfer has been given, allowed. Which part?
In the recent order, I am of the opinion that the academic interest of the students of Bandhabhushan Junior High School, Purva Mednipur, should not be compromised even if the transfer application of
Oh yes, I got it.
Sujit Paik is allowed.
I got it. কি বললাম?
Pursuant to the direction, the order was passed on November 23.
Allowing the transfer, annexure such and such, allowing the transfer of the petitioner. However, the second part of the direction has not been complied since no effect was given to the said reasoned order. Poster. Paragraph. Mr.
Sanjit Das. It's Sanjit Das.
Shonjib Dash, you are in state panel.
Yes.
Mr. Shonjib Dash, learned advocate, appears for the alleged contemner. Both contemners. Poster.
Lordship, contemner number 1.
Why
That
not
is the commissioner, and second the SSC.
That's right. So why we have made two contemners?
That is the order, the the reasoned order is to be forwarded to the SSC. That's why the
Okay,
SSC
so
is to be
carry to who shall give effect? Transfer,
SSC.
transfer.
Not been served upon us, whether we,
Not required. It's contempt on the first day.
yes,
The question is transfer allowed. Now, who shall give effect to that?
I will have to see with that by transfer allowed what exactly has happened, because it goes through several stages. If we have recommended for transfer, then it goes to the board and the appointment will be issued. The order,
That local arrangement has done, local arrangement has made, and commissioner of school
Okay,
education.
okay, 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 okay.
so it does not get.
Okay, 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 okay. Mr.
Sanjeev Das.
Learned advocate appears for alleged contender number. You are the two chairman.
Fine.
Alleged contender number 1. You don't know for whom you are appearing, sir.
My lord, I'm junior. Mr. Sanjeev Das is appearing in court number 8.
And you are saying you are Sanjeev Das. I'm asking you, who are you? কি হবে? কি profession কোথায় যাচ্ছে? Contempt এ none appears. না তো বলা দরকার নেই, appear করার দরকার নেই, ছেড়ে দিন। আচ্ছা, ফুল স্টপ। লিখবেন না, না। Contempt এ Dr. Shutanu Kumar Patra, Learned Counsel appears for the alleged contender number 2. Full stop. He submits that he needs to take instruction as to what stage the matter issue is lying. Full stop. Paragraph. Contender number 1 এর কেউ নেই। Cut it off. Paragraph. Considering the above, the petitioner shall serve contempt application upon both the alleged contenders positively by December 18, 2024. Full stop. The proceeding shall appear under the heading contempt application on December 22, 2024. 3. ওটা 2023 করেছেন তো পরেরটা। December 18, 2023. Our contempt appear করবে under the heading contempt application on December 22, 2023. Paragraph. In the event, upon further consideration, it appears to this court that rule is required to be issued, the same may be considered by this court on the next day. Full stop. However, pendency of paragraph, pendency of this contempt application shall not preclude the alleged contenders to carry out and give effect to the to carry out the direction of this court. In the meantime, it's a contempt application. Your junior knows nothing. You have allowed him to come. Excellent. No, no, absolutely. You're so busy.
There is also contempt.
No, 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 absolutely. So, compliant.
No, I have to file compliance report.
Whatever you want to do, you do it on the next day. Otherwise, I shall issue rules straight away.
Grateful, Lordship.
I appearing on the alleged contender.
কি বলেছি? ভাই হ্যাঁ ওটা রাখুন।
Lord, may
No further.
Lord, the copy of the served upon me,
চলো।
so that Lord, wait a minute. Copy of the application will be served upon me. But this is
If copy is not served, rule will be served
No,
on the
because
next day.
I have
Let me
not-
see. There must be some limit somewhere. In a content petition, you're a junior member of the bar, you have sent your junior who knows nothing. Absolutely no blame on him. No blame on him. Chalo. Case 12.
12 minute, I am for the petitioner. But this is the contempt application appearing for the first time, Lord. Your Lordship was pleased to pass order on 10th May 2023, appearing at page 16 of your Lordship's brief. But this is a matter of but this matter, my lord, pertains to payment of pension to a retired teacher, my lord. He retired on November 2022. Till
Show me
date,
the direction. Show me
yes,
the direction.
I'm straightway coming, my lord. Page 18, Lordship sees the first paragraph, third line. The respondent number 5 then in turn shall take all necessary and consequential steps to pay the pensionary benefits in accordance with law to the petitioner positively within a period of 3 weeks on the date of
Reasoned order has gone in your favor.
reasoned order, yes. The pension sanctioning authority says the certain steps are to be taken and it may be paid. Then second, third, fourth paragraph, there is also direction for payment with interest. These two are the, my lord, acts of contempt.
Reasoned order has gone in your favor.
Yes.
Show me the page.
Yes. Page 24. 24 is the reasoned order. 25 is the operative portion. Really speaking, my lord, the government authorities have said that yes, the pension may be sanctioned. It is due to the mischief of the school authorities. They are not sending the papers correctly. This is the sum and substance of the story.
You have made the school authority.
Yes,
as
I have also
contemner.
made him a party.
Contemner.
Yes. He is the fourth contemner. Lordship kindly considers page 25.
Yes.
May I read it for your lordship? Considering all, third paragraph. Considering all these submissions of the petitioner and the school authority, the district inspector of school secondary education Paschim Bardhaman is requested to submit the pension papers in respect of the petitioner to the district inspector of secondary education Purbo Bardhaman after verifying and scrutinizing said papers.
So who are the alleged contemner now?
Alleged contemner is both the district inspector of schools.
Come on, from your cost title, sir.
Yes. Alleged contemner is page
Against
4.
whom rule shall be issued?
Page 4. Against all of them. Against all of them.
Reasoned order passed by?
Reasoned order passed by
DI.
contemner number 2.
Then why he shall face the rule?
Well, he is the pension sanctioning authority. Everything has to be scrutinized and processed through him only.
Very well. Ashok. This is a contempt proceeding arising. Show me the contempt notice.
Yes. Contempt notice is at page 40. Yeah, that's
After the reasoned order was passed.
yes, after the reason.
Ashok. This is a contempt proceeding arising from the order of this court dated May 10, 2023. Paragraph. Pursuant to the direction of the content proceeding. Direction of this court. The reasoned order was passed on. Sir.
Well, reason was passed on
July 18,
18th of
2023.
July. Yes.
Annexure C at page 24 to the content application. The reasoned order has gone in favor of the petitioner. So, paragraph. The order dated May 10, 2023 had two parts. The first part to pass a reasoned order, and the second part, if the reasoned order goes in favor of the petitioner, then to give immediate effect thereto. Paragraph. Mr.
Sandeep Kumar De.
Sandeep Kumar De, learned counsel appearing for the petitioner, submits that though the reasoned order has gone in favor of the petitioner, but the alleged contemners had failed to carry out the direction of this court by not giving effect thereto. Hence this contempt. Referring to a notice dated September 25, 2023, learned counsel at page 40 to the content application, learned counsel for the petitioner submits that the notice has duly been served upon the alleged contemners. Paragraph. In view of the above, there shall be a rule issued. ওখানে to be issued বলেছি না, ওটা হবে না, না shall বলছি আবার to be না, there shall be a rule issued upon the alleged contemners. Full stop. Paragraph. The department is directed to draw, complete and serve the rule at the earliest. The rule is made returnable on January 19, 2024. Full stop. It is, however, made clear that pendency of contempt application, this contempt application shall not preclude the alleged contemners to carry out and perform the, to carry out and comply, to comply with the direction of this court dated May 10, 2023. In the meantime, totally. Full stop. Paragraph. The proceeding shall appear under the heading contempt application on January 19, 2024.
Now, kindly allow me to read slowly the act.
Yes, yes. You proceed in your own way. No hurry. You proceed in your own way.
I'll just read the preamble once again, whereas it is expedient.
Wait. Today we are on 15th. Preamble.
Now, let whereas it is expedient to provide for establishment from the Act.
Yes, whereas
it is expedient to provide for establishment of West Bengal Administrative Adjudication of School Disputes Commission for better protection. Now the object for better protection of rights of teachers and non-teaching staffs of school in the state and for efficient disposal of the school disputes for the matters connected therewith or incidental thereto. There are two things. The object of the act is to protect the rights and of the teachers and non-teaching staffs as a class and to resolve their disputes. Now, for that purpose, now if you kindly travel once to look into the judgment cited of 1988, just one paragraph, then I'll come again to the act.
1988.
Yes.
88 which?
Already handed over, 1988 4 SCC, page 42.
ওইটা already cool. ওই তিনজনের যেটা হয় না?
There was a separate file.
Judgment. ওই জন্য লিখে দেন হার্ড অন জাজমেন্ট সেম ডেট। ওটা আজকে সার্ভার আর ছোটটা সার্ভার করে দিন, কাল সই করে দিয়ে গেছে। কি?
Have you got it?
88.
1988.
Yes, got it.
4 SCC, page 42.
One second.
First paragraph, just 2 lines.
One second. Which paragraph?
First paragraph first. The short question which arises for consideration in this case is whether a teacher employed in a school falls within the definition of the expression workman as defined in section 2S of the Industrial Disputes Act 1947. Now let paragraph 3. Two question arises for consideration in this case whether the school in which the appellant was working was an industry, and then whether the appellant was a workman employed in that industry. It is, however, not disputed that if the appellant was not a workman, no reference under section 10(1)(c) of that cannot be done. Be sought. Now let straightway paragraph 10. In 10, it was held that no, teacher is not a workman. Therefore, no reference. Then my kindly takes up paragraph 11.
One second. Then 11.
10 held in negative. Then 11. We may at this stage observe that teachers as a class cannot be denied the benefit of social justice. We are aware of the several methods adopted by unscrupulous managements to exploit them by imposing on them unjust condition of service. This is very important vis-a-vis the preamble of the Constitution. In order to do justice to them, it is necessary to provide for an appropriate machinery so that the teachers may secure what is rightly due to them in number of states in India, laws have been passed for inquiring into the validity of illegal and unjust terminations of services of teachers by providing for appointment of judicial tribunals to decide such cases. Now, while this judgment was passed, there were few states where laws were there by which tribunals was formed to decide the cases of the teachers, keeping in mind that to ensure justice to them. Therefore, my submission is this
is in 1988.
1988.
Now, when this 2008 was promulgated,
the same principle follows.
It was in the knowledge and notice of the legislature.
Now, last line of this paragraph, it says, we hope that this lacuna in the legislative area will be filled up soon. The requirement of preamble has been envisaged in this judgment, and with a direction, with an expectation, the legislature will fill the lacuna. Now, in 2008, kindly comes to that. Now, our act. This lacuna has been filled up by this enactment. That's why teachers and non-teaching staffs as a class, they were protected by this enactment. Now, what has been provided in this enactment? I'll try to demonstrate that entire power of High Court has been shifted to this commission. Now, kindly see. Now, kindly take some section 2. Administrative member means a member of the commission appointed as such under section 5. And then clause B is also important. Bench. Bench means a bench of the commission. Now, school means study, we have shown that it includes unaided schools. Then dispute, school dispute also have been shown. Kindly see school disputes, first one. I am trying to demonstrate that even at the time of establishment of school, whatever disputes arises, that has been taken into consideration by under this act. Why so? School disputes, first determination of staff, then inquiry or in inspection, funds, service matter, sanction of strength, selection of sites for setting up the school. And everything has been covered. Now, kindly takes up section 4. The commission shall consist of the chairperson and not less than one legal member and one administrative member. The provided that the number of administrative members shall not at any time be more than number of legal members. This is important. Now, this is in compliance of L. Chandrakumar. Yes, tribunal.
This is the tribunal.
Right. Then
no, the commission.
Commission in the form of tribunal. Yes. Then clause 4, subject to provisions of this act, the jurisdiction and power of the commission in the matter of adjudication of the school dispute may be exercised by a bench. I have shown the definition of bench. So there are benches. A bench may be constituted by the chairperson with 2 or more members of the commission, as chairperson may deem fit, provided that the number of administrative members in a bench shall not at any time be more than a number of legal members in the bench. The bench shall sit at the principal seat of the commission or at such other places as the state government may, in consultation with the chairperson, notify. State government shall notify the area in relation to which bench may exercise jurisdiction. This is territorial jurisdiction. Then 5. A person shall not be qualified for appointment as chairperson unless he is qualified to be or is or has been a judge of High Court. Important. Then clause 4. The chairperson shall be appointed by the governor in consultation with the Chief Justice of High Court. The member other than the chairperson shall be appointed by the governor on the recommendation of the selection committee consisting of chairperson, secretary, law department, West Bengal, secretary, school education department. Then Malad kindly takes up section 10. This is staff of the commission. And then section 11. This is also important. Section 10 staff of the commission. Section 11 is also important.
Superintendent power. Of course, chairperson has to have a superintending power
over the all other benches.
Like the managing director of a bank will have a superintending power of all its branches.
Now, Malad kindly takes up section 12.
12 and 13 you explain.
Yes. Now, Malad 12. Malad kindly read. This is actually
the state act,
a provision
to which this act
shall
apply.
This is a
acts to which this act shall apply.
This is a provision which excludes jurisdiction of civil court and nothing else. Now, Malad kindly read it. This act shall apply to every specified act with effect from such date as the state government may, by notification, appoint and the commission, save otherwise expressly provided under such a specified act. And
save otherwise
expressly
provided
under such a specified
acts.
Which has been provided. I'm coming to
only to that extent, saving clause.
Right. And subject to other provisions of this act. Shall exercise jurisdiction, power and authority in relation to all matters of jurisdiction. Now, the purpose of this enactment, provisions. Shall exercise jurisdiction, power, authority in relation to all matters of adjudication or trial of any school disputes and matters connected therewith or incidental thereto, semicolon. Pause and then, and no civil court shall, with effect from such date, exercise any jurisdiction, power, or authority in the matter of adjudication or trial of any school dispute. The next clause is clarifying the purpose of first clause. Clause 2. Notwithstanding anything contained elsewhere in this act, all proceedings triable by any court or courts in accordance with the provision of Code of Criminal Procedure. Married. Notwithstanding anything contained elsewhere in this act, all proceedings. In the first clause 1, bar of civil court. Now, second part, notwithstanding anything contained elsewhere in this act, all proceedings triable by any court or courts in accordance with the provision of Code of Criminal Procedure shall continue to be tried by such court, and the commission shall have no jurisdiction to try such proceedings. So, first provision is that whatever dispute under the specified act and yes.
This has got nothing to do with you. It is a specified provision for specific proceedings under Criminal Procedure Code.
I'm not on that. I am on
If
second clause.
like if a teacher suffers a criminal proceeding initiated by the school, let's say for whatever reasons, then this commission will have no jurisdiction. It shall be tried by the specialized
Grateful to it.
criminal.
Grateful to it. So that first clause says that whatever grievance you have under the specified act or any provision under this act.
Show me that or.
Now let
Show me.
first, second, third line.
Read it. This act shall apply to every specified state act with effect from such date.
And subject to other provisions of this act. And subject
Save
to
as otherwise expressly provided
yes,
under such specified act
right.
and
Subject to other provisions of this act. Shall exercise power.
So here, up till now, of course, subject to hear you all, up till now, my reading is those specified acts has to be there. Whatever offense committed under those specified act shall be tried
By this commission.
Plus,
And civil court has no jurisdiction.
thirdly, plus, if any offense committed under this act.
Also be tried by the commission.
So, the institution must be under that specified act. And whatever provision violation under this act, both have to be tried under this commission. Let us read it again.
Now let
the act shall apply. This act shall apply
to every specified act.
state act with effect from such date as the state may by notification, blah blah, save as otherwise expressly provided under such specified act. Save as otherwise expressly provided under the said act and subject to the other provision of this act, which means if a provision is excluded under that act and subject to provisions like criminal proceeding, then the commission will not have jurisdiction.
First clause is whatever grievance you have under the specified act and subject to other provisions of this act.
Subject to, it is not that including other provisions of this act or there is no or other provisions of this act. Subject to means the method of adjudication
has been specified in paragraph clause 13.
Method of adjudication, the scope of adjudication by the commission shall be subjected to this act, but disputes must relate to the specified state act.
Dispute in the state specified act will also be adjudicated.
Absolutely.
Will also be adjudicated.
Absolutely.
By this commission.
Disputes in those specified state acts subject to the provision of this act, like a dispute in the specified.
Now let kindly take some paragraph 16 once.
Section 16. Yes.
Kindly see the extent of power given to the commission. The commission shall be a court of record.
Absolutely.
And shall have all powers of such court, including power to punish for contempt of itself.
Yes.
The powers refer to
Central Administrative Tribunal Act.
Right.
Right.
It does not confine to specified act. Why so? Once again. You can challenge করতে বলে provision টা বলো। That section 13. 13, can I take up 13 first? Then I'll come again to the section 12.
Yes, 13.
Save as otherwise expressly provided in this act, Commission shall have jurisdiction to adjudicate a school dispute and make order to a person directing redressal of school dispute. Not, there is no limitation.
What limitation?
All school disputes, whatever disputes
Has to
as
be read,
defined.
has to be read in the light of section 12.
But then I'll come. In particular,
12, but 13 cannot be read
in isolation.
of 12.
And 12 cannot be read to renew the power given under section 13.
12 is the substantive and exhaustive provision.
Rather, 13 is the exhaustive
No,
provision, not the 12.
13, no, 13 is the jurisdiction of the commission. It is
Fine.
only the jurisdiction of the commission. It is
Rightly
not,
so.
It is not in an exhaustive provision.
That's why I'm saying
12 is the exhaustive provision.
13, if it speaks of jurisdiction, then by 12, it cannot curtail the jurisdiction.
But to reach at 13, first you have to satisfy 12. To reach at 13, to go to 13.
My submission is 12 is entirely different purpose. I'll come to that. As 13.2. In particular, and without prejudice to the generality of the provisions of subsection 1, the Commission shall, in adjudicating a school dispute, have jurisdiction to declare that a law or an instrument, statutory or otherwise, or an act has all or shall have such effect or no such effect. It does not specify that those specified act. It's
not required, sir. The moment you qualify the test of 12, you have a passport to entry at 13.
I'm coming to that also.
So when 13
and now let's
exercised,
straightway come to the proviso of section 2.
2.
Section 13.2.
Yes.
13.2 proviso.
Read it.
Provided that for the matter relates to disposal of question of constitutional validity of any provision of the specified act, the matter shall be decided by a bench constituted at least 3 members, of which chairman shall be 1. Therefore, even the specified act,
ultra vires point can be decided, like sales tax tribunal, which we commonly call super tribunal, which exercises the power of 226 basically insofar as restricted to declaration of ultra vires.
clause proviso always clarify.
Correct.
It does not take away the main provision.
Absolutely not.
Now, main provision says a law or instrument, statutory or otherwise, or an act has or shall have, and there is nowhere it has been stated a specified state act.
Not required, because to get an entry to 13, you have to cross the test in 12.
No,
to
where from?
The test in 12, you get an entry into 13.
May I read till 12 once again?
Okay. I don't mind. You proceed in your own way. It's an interesting point. Let's see.
Now, this act shall apply to every specified act.
This act
shall apply.
It doesn't say shall also apply. It says this act shall apply.
Can you don't put word in the statute?
We cannot.
This act shall only apply. No, not there.
No. So this act shall apply.
Shall apply.
Shall apply means it's a mandate.
So this act shall apply.
Mandate.
This act shall apply. Make it simple. This act will be applied to specified state act with effect from such date as the state government by notification appoint. So the specified act shall be applicable under this act from the date when the state government by a notification appoint. First line.
Correct.
So immediately after this commencement of this act, what we get recognition that the school teachers and non-teaching staffs is a class and public element is involved on the day of enactment when this was notified, this act. Am I clear?
This act shall apply to every specified act, save as otherwise expressly provided under specified state act, and subject to other provision of this act, shall exercise jurisdiction, power, and authority in relation to the matters of adjudication of trial, school dispute.
There is a principle called conditional legislation.
Condition, yes.
Now, if you let us kindly takes up, ask this slowly. Section 1, clause 2.
Yes.
Primarily, the procedure of any legislation is the bill has to be placed to the assembly. It has to be passed. Thereafter, it will be sent to the governor in case of state. After taking assent, it will be notified in the Gazette. Immediately it is gazetted. It is act. It is an act.
Promulgation complete.
Promulgation complete unless there is any condition.
Always.
Now, 1(2), clause 1(2), it says it shall come into force on such date as the state government may by notification appoint. So this appointment is appointment of commission.
No.
Basically.
No. No.
Right.
It shall come into force, the act itself.
This act will come into force.
Act itself. Commission is a part of it.
Yes, commission is part of it.
Then
what I'm
the act, see, while notifying, as I repeat again, like Companies Act 2013, while notification, a restrictive covenant was there that chapter blank to blank, say about containing 300 sections, they are not notified now, they will be notified later on. Possible. And done. For Companies Act 2013, it was done like that. Right? That is why initially when 2013 Act came into force, for quite some time, the merger amalgamation, they went to the tribunal, but the winding up remained. 397 went for 441. Mismanagement went. Winding up remained. Misreasons remained. Thereafter, gradually notified. Possible. It is not such.
This is conditional legislation.
It is not such. It is a blanket legislation. It shall come into force on such day as the state government may by notification appoint. What appointment? What appointment, sir? This is not the appointment of the
this is not the appointment of the commission.
You said this just now, it appointment
I'm
of
saying that
commission.
the
It cannot be.
act is implemented. To implement the act, there must be a notification for appointment. Now to clarify.
Basically, state list act.
Right.
It's a state list act.
Now in section 12, if you kindly takes up once again, this act shall apply to every specified state act with effect from when with effect from such date.
Notification.
Notification. So long this notification is there, section 12 has no effect.
So long the notification
Is
not
not
there.
made.
Not there.
Not there.
Yes, say that.
Yes.
You said
I'm
there.
sorry. Oh, I'm sorry.
Let it sound. Not there. Naturally, if the notification is not there, the act will not see the light of the day.
No. So far act is concerned, this notification has already been made.
This is the notification.
My humble respect for submission is no. Even in case of Fair Compensation Act 2013, there was an appointment date. And that appointment date was made in 2015. So far, few acts is concerned. In 105 of 2013 Act, it says central government by notification appoint a date for application in respect of National Highways Act and other few central acts. So long this notification is made, those acts were not applicable. So far,
So according to you, this act has not been applicable at all.
No. This section 12 has not been applicable, has not been made applicable. So long the appointment notification is made.
Appointment is not the appointment of the commission.
I'm not saying so. I am saying
that appointment is not made, then this act is also not has seen the day of the light of the day.
that with due respect, no. This act shall apply to every specified act with effect from such date. Which is the date? As the state government may, by notification, appoint. The state government
So
has to,
You mean there has to be multiple notifications?
by a separate notification, appoint a date. But there are notifications. I can cite it before lordships.
So according to you, there will be multiple notification.
Yes.
One is this, the gazette notification.
By this notification, act has been promulgated.
And 12 is not part of that act.
No.
Fantastic. What you are submitting, sir? What you are submitting, sir?
That with due respect, no, my lad. Section 13 does not require so. Section 14 does not require so. It has been promulgated immediately with the act is promulgated.
Very well.
Now, my lad, even then, that even if I assume that section 12 has been promulgated with this act, even then, it does not confine the specified act. Rather, the very object of the provisions is to not exclude the jurisdiction of civil court.
Correct.
And to decide that this commission is the court of first instance, where to approach.
Now, if this means school dispute, this is not qualified. Now, if this act, if his argument is taken to be into account, that as this school does not come within any of those 7 acts, specified acts, then where will you go? Tell me.
If
this school does not come within the scope of either of those 7 acts schedule, which are the specified state acts, where will you redress your grievance?
Well, I don't have any that provision. There is no provisions to redress my grievance.
You don't have the provisions?
No provisions.
So your grievance will be remain unredressed.
Unredressed. Why I say so, my lad? The 88 judgment says I am not a workman.
Correct.
Now, my lad, section 14 of the specifically that says, so far my termination is concerned, no specific relief can be given. There was no civil court. Therefore, my lad, in no civil court.
Why?
Section 14.
What 14? Show me.
That there are judgments of our High Court, of Supreme Court, gallons,
If I hold tomorrow that you are not covered by this act,
I don't have any remedy.
What you are saying, sir?
But I am saying that with all responsibility,
Yes, show me, sir. Let's read section 14.
Excellent.
The plenary jurisdiction will go.
Yes.
Of a civil court.
Yes.
Show me.
আচ্ছা, কোর্টের একটা প্রশ্ন এসছে মানে একটা জবাব দিতে হবে তো।
Show me.
ওই ওই লোকটার কি নাম ছিল কি? অসীম তালুকদার।
Statement হবে না করে।
For damage only.
I'm sued for damages, not
Only damage.
not reinstatement.
No reinstatement. That's my point, right?
Every relief you will get.
No.
Every
That Supreme
relief.
Court has clarified.
Every relief you will get. What you are saying, sir? Show me 14.
Just a second, wait.
Hey, Didi, section 14 specifically cat Google मारो print out दिन.
বার করে স্পেসিফিক একটা বার করুন।
Interesting point. You argue in your own way, not an issue. Interesting point.
Now, this provision is
Let me see. Sir.
contract not specifically enforceable.
Correct.
Right.
And 41 is you cannot injunct somebody to initiate a legal proceeding. Where are the other bar in specifically?
And this provision has been clarified by Supreme Court time and again. So far, service
You bring those Supreme Court.
service matter is
Bring
concerned.
those Supreme Court that service matter is concerned. Prior to promulgation of Industrial Dispute Act, no civil suit would have to lie.
No, I can file a suit for damage. Not for
You can file a suit even for declaration.
for reinstatement in my service.
Of course, you are not covered under this statute.
I'm bringing those judgment, right?
Yes. If you are not a workman, Diki din, section 14.
No, with due respect, this has been clarified. I have gone through those judgments.
No, it's all right.
Because I had occasions.
I always believe, Mr. Ahmed, these are really exchange of intellects between the two sides.
That always, right?
Yeah, but I mean, so
Well, so long these judgments are right. Coming right, kindly take some section 12 1 second. Right? May I right, continue? Right?
As I said, you are welcome. Don't worry.
Those are excluded.
Mark for
Payment of compensation. West Bengal Board of Secondary Education speaks no.
Mr. Ahmed, let me give you an example. When Industrial Dispute Act came into effect,
47.
came into force,
50 around, I guess.
in or around
50.
Prior to 50, you will find galore of glorious judgments of our court as well as Supreme Court settling diverse points of law on labor and industrial disputes by way of civil suit. The moment a special statute came into effect, as I give you a simple example, which we have seen the days in our generation, because we are also aging, growing old. Like bank suit. Previously, when we joined in the profession in 95, bank suits were flooded. High Court was flooded with bank suits, right?
In service matter.
No. I'm giving an example for recovery of debts. Bank suit, it was flooded. First prayer, recovery of this amount. Second prayer, enforcement of pledge or mortgage. Third prayer, declaration, consequential to pledge or mortgage. then blah, 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 consequential. Now the time has come, 2003, 1993. DRT Act came into force, which gave effect little later. Bar was perhaps under 34 or whatever, civil jurisdiction.
Surface Act.
Lock, stock and barrel went to tribunal. First, the virus was challenged. The tribunal initially could not have decided the mortgage or hypothecation declaration part. Then amendment came in consonance with CPC, power given. But what happened? Civil suit would not lie. Similarly, you are not an workman. Settle. So, you have a bar to approach the tribunal. Fair enough. If I hold that you were also barred under 12, Section 12 of this Act, then where your remedy will lie? Will you be non-suited?
That's my point.
That can be the law with the plenary jurisdiction of civil court. Can that be the law?
Supreme Court says so.
Supreme Court says so.
Our High Court.
Let me see. How our High Court has said. Let me see, sir. Let me learn also. Then the expression would not have been used. Plenary, and plenary. Show me.
We are in fact digressing from our point still.
No, we are not really digressing. You said you will have no remedy.
Yes.
Where I joined the issue. Of course you have a remedy. Yes. Academically, it may be a remedy of 30 years, 40 years. That is neither here nor there. If law provides for it, you have to go for that. I'm coming within 2 minutes. Yes.
Like, this is a judgment of like 2023.
Give it to me.
iPad appeal আমি করতে পারবো Mr. Joyন্ত Mitra was the counsel man argued in the matter then, and then he has cited Supreme Court judgments that right from the beginning, 60s, from 60s, all judgments has been cited, and thereafter that conclusion has been drawn by the based on those judgments. I'm reading and a contract of a private employment is not similar to the public employment. And in such private employment, there is no scope of applicability of principles of administrative law or public law. A contract of employment which provides for termination of services by 1 month's notice, then at best the employee will only be entitled to 1 month's pay in terms of employment of contract.
Damage, basically.
Damage. An employee is not entitled to any relief of continuation of service or pay with consequential benefits for alleged remaining period of service till the date of superannuation. As per provisions of section 14(1)(c) of the Specific Relief Act 96(3), a contract which is determinable in nature cannot be specifically enforced.
Absolutely. Absolutely.
Since
who denies?
Since
because I tell you the reason. Let us understand the first principles of law. Why? A contract, the moment is executed between you and me, if it is snappable or terminable for both the ends. Correct?
1 month notice.
1 month notice.
End.
Let's say I don't give you a 1 month notice. I terminate your contract. Termination will be bad. Per se, the compensation of 1 month salary. Right?
Right.
Second limb. The moment I will terminate your contract, the fundamental principle has to be, I presume, a breach on your part. Which means I have to have reasons for breach. Now, if those breaches are illegal, then termination will be declared as void. That's the consequence of law. That's the consequence of law. So what will happen? Termination stands. But if it is in breach, then of course the termination being bad, the contract cannot be directed to be rejoined, but you will get the compensation and damages.
Right.
So that's a different principle of law altogether.
That's that. Now, since there is specific provisions that this contract is determinable, every contract in service.
Yes.
Then there is no scope for reinstatement.
Very well, let's say yes, then.
That is the decision our High Court held in 2023.
Perfect.
Now,
if your remedy is provided under law, you will have to apply the civil court. Even if it is not reinstated, if it is not reinstated, you will get your compensation. That's the law. What to do? What to do?
Now, again get back to 1988. What 88 says, that because of these private contracts,
give me that.
Because of this private contract, people are being exploited, which is against the principles of our constitution, particularly in the preamble.
Yes.
That is the scope of 19...
How 88 help you here? Even admittedly, you are not a workman.
As of now, we are agreeable to the point that this private contract, which is determinable, cannot be enforced and I cannot ask for reinstatement.
Don't ask.
Up to this,
Correct.
that there is no quarrel.
Correct.
Therefore, Milord, if
What would you ask before the commission here under the act?
Reinstatement.
How can you ask then if it is not specifically enforceable? If it is not specifically enforceable, then in law it is not specifically enforceable.
Let any dispute, let kindly see the disputes. All dispute is determinable.
Absolutely. Absolutely. Now, if you go out of the scope of this act, then what will happen? Tell me.
If this act is nowhere, it doesn't
Let's
exist.
say the act is
Doesn't
not there.
exist. Then again, there is a bar in specifically fact.
Why?
I cannot ask for reinstatement. Settle law.
If it is, you are not asked for, if you are not entitled in law to ask for reinstatement, you will not be entitled to ask for reinstatement. Matter ends.
Right?
Matter ends.
Now in law, in private contract of service, it is not enforceable.
Correct. If it is not enforceable,
So
it is
this
not
specific
enforceable.
relief act was there in 1988. Now what Supreme Court has said, let
What Supreme Court has said, tell me.
may I go again slowly.
You are free to argue, you are
That
welcome.
Supreme Court, that Constitution always prevails.
That's the source.
Now let Supreme Court in 1988 says, in absence of any specific laws, people are being exploited at the instance of these private employers, and suggest, rather made a request to the legislature to enact this kind of legislation.
Look into it.
It also records there are few states which has already enacted this kind of legislation. At the beginning, let I have submitted the scope of the act vis-a-vis the public law element is involved by this enactment and what the legislature intended to do to protect the rights of the teachers and non-teaching staffs.
But what to do if section
Now,
your language is
I'll come to
providing
that.
for specified time?
Now, let us come again to that section 12. Now, let before section 12 come to let school disputes once. I'm sorry, I'm repeating.
No, why not?
But
You are free
2K.
to do it. You are free to do it. Whatever.
Section 2K.
You are arguing a matter. No issues. 2K.
School dispute means all disputes relating to. Now, let
let me tell you, let me be very clear. I admit that your dispute is a school dispute. I admit. You simply come out of the rigor of 12.
Now, I'm not on whether I'm covered by section school dispute or not, I'm not on that. I am on the scope of school dispute.
I admit you have a dispute which is a school dispute.
To demonstrate that there are few disputes refers to under this school dispute which cannot be a subject matter of those specified acts.
May not be.
If these provisions...
Then where your remedy will lie?
No. This enactment speaks of certain disputes which cannot be subject matter of a specified act. Then what was the reason for keeping those provisions in the definition of school dispute?
The legislature thought it fit, did it.
The legislation thought it that it does not limits to section 12. That's the reason. Now, what are those provisions? Kindly see,
Section 12, I tell you, Mr. Ahmed.
And not only so, kindly see
section
last clause of school disputes.
Section 12 is the license clause.
Not really.
To apply under the act.
Rather, section 12 application depends on the other provisions of the act. I'll come to that. But kindly see last provisions of clause 9 of school disputes, any other matters which may be prescribed. Therefore, scope may be expanded further.
Yes.
Again, let's come to that's the reason 12 cannot be interpreted like this, only specified act. We have to read section 12 along with the provisions of other specified act. Now, what is section 12? Kindly leave first two line of the section 12, third line, and subject to other. Subject to other provisions of this act. Therefore, application of section 12 is dependent on other provisions of this act, and no other provisions of this act refers to section 12, that all these provisions is subject to section 12 of the act.
This is the charging provision. 12 is the charging.
The enabling provisions.
12 is a exhaustive provisions which gives you a right to approach under this act.
Once again, subject to other provisions of this act means whatever is there in section 12 will be applicable subject to other provisions.
Right. Like section 12 specified that, let's say, provides for some criminal offense also. For example.
That is not such.
No. For example. But the other provision of this act, subject to the other provision, says criminal proceeding, no. Then it will be a no. It will be a no. That is why this expression used.
Again, let's read other provisions, then main provision shall exercise jurisdiction. Now, the scope. First line, this act shall be applied on the date of appointment, first line. Second line, commission otherwise expressly provided in the specified act and subject to other provisions, second line. And third, if these two satisfies, then shall exercise jurisdiction. Powers and authority in relation to all matters, adjudication or trial of any school disputes and matters connected therewith or incidental thereto, and no civil court shall. So the purpose of this provision is ouster of civil court, and clause 2, the non-obstant clause.
When ouster of civil court, if you come within the scope and purview of the
section 12
portion, section 12 first portion.
In case of any dispute under
And
the
if you don't come within the scope and purview of the first portion, then your remedy is before the civil court.
Purport of the section is, if it is a specified act, then court of first instance would be the commission and no civil court.
And if it is not under the specified act?
If it is not under the civil court, specified act, then section 13 would be applicable. Because section 13 never says subject to section 12.
Very well, you argue. 12 is the passport. Unless you satisfy 12, you cannot go to 13.
Section 13 must include the reference of section 12.
Certainly not. Certainly not. Most certainly not. Then every section will have to refer the previous section. Subject to section 9 shall refer subject to 8. 10 shall refer subject to 9. 13 shall refer subject to 12. Sorry, no.
Let's subject to other provision.
The scheme of the act is not that. The scheme of the act is not that.
That section 12 does not, if the section 12 is the main provision, then section 12 does not require subject to other provisions. Rather, If section 12 is the main provision, then other provisions requires at anywhere the subject to section 12.
Other provision does not speak of application of specified state act. Other provision says the restrictions imposed.
13 does not confine. 13 says all school disputes.
That's right. Within read has to be
Never
read.
said. Your lordship is putting words in section 13.
Sorry, no. Very well. You read. You are in your own way. 13 has to be read in the light of the 12. Has to be read. The ray will come from 12 on 13. Has to be.
But section 12 never says jurisdiction of the commission.
No. Jurisdiction of the commission says how the commission will function and to what extent. That's the
What is the jurisdiction of the writ court? What is the jurisdiction of the writ court? That does not mean how writ court functions. What is the jurisdiction of writ court means the scope of judicial review.
Not judicial review is a part of writ court. Is a part of
right, right. How the writ court will function, that is not the scope. The jurisdiction is, so far this High Court is concerned,
yes.
The jurisdiction is that the cause of action must be within the limit of state of West Bengal.
It's a territorial, forget it.
Territorial and violation of any fundamental rights or legal rights and vis-a-vis the scope of judicial review.
And an Article 12 authority.
Not
against an Article 12
not
authority.
necessarily. Not necessarily. Again, not necessarily. Even Supreme Court says, but not in this case.
Discharging public function, yes, like CSC.
Right.
Yes. Discharging public function, yes.
And violation
Discharging imparting of education, yes.
Violation of Article 21, again a private individual.
Absolutely. 200% agreed.
So, the scope of and the jurisdiction of writ court is section 13, not section 12.
The jurisdiction of 226 is the involvement of public law element. That's the elementary.
Right.
Elementary.
School disputes.
Elementary.
School disputes.
Elementary. Show me from Article 226 what is the language.
Okay.
Show me for Article 226 what is the language.
Constitution.
देखिए Constitution कोई बोलता यही तो धारे rules. Show me that it is mentioned as like school dispute, that language mentions that.
And I have never said so.
You said that 13 means school disputes. I said 220. Then you come to the comparison of 226. I said compare 226. Public law element has to be involved. Now let us examine the language
That
of 226.
if your lordship agrees
yes,
that public law element has to be there,
yes,
then immediately this act promulgates.
right.
All school covered.
But if you are not covered under that act, what will you do?
Well, that is for the purpose of remedy.
Come on, read 226.
Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction, territorial, to issue to any person or authority, including in appropriate cases, any government within those territories, directions, orders, or writ includes writ in the nature of habeas corpus, mandamus, prohibitions, quaranto, and certiorari, or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose.
So where is the school dispute? As you have said in 13?
For enforcement of any right, I can come to this court.
So where is that mentioned in 226? You have said 13 mentions school dispute, therefore whatever school dispute. 12 is not to be looked into. That is your submission. Your submission is 12 shall not to be looked into when I apply under 13.
12 is an enabling clause for the purpose of certain disputes.
12 is the exhaustive clause.
13 is the exhaustive clause.
13 is a limited clause to the extent of commission's jurisdiction.
Milad, kindly don't read only in section 12.
Otherwise, it's not exhaustive.
If your lordships read only in section 12, then I have no case. I don't waste your lordship's time.
This act shall apply to every specified state act.
Don't include only. I'll not.
Where is only? Only is not there.
Kindly don't read it in mind.
No, I don't read it in mind.
Then, if your lordships read it in mind, then I don't have any case. I'll not waste your lordship's
Sir,
time.
whatever I will read, I will give my reason in the judgment. But
No.
here, this act shall apply to every
Specified
specified state act.
Let it apply.
Let it
To,
apply.
to all.
Then with effect, then subject to other provisions of the act.
Right. It never says it not apply to others.
Subject to other provisions
Of
means
this
the
act.
restrictions.
Sub 13?
What are the 13?
13, can you read? All disputes.
All disputes.
Yes.
School disputes.
All school disputes.
Right. Now the moment you read specified state act.
No, I don't read. Kindly see. Again, if your lordship reading only.
No, I'm not reading only.
Then again, kindly read.
State act.
Let all specified.
State act, state specified act, plus subject to. That should be the actual reading of section 12.
Plus subject to. In respect of a specified act.
Yes, no. Specified act is a condition.
No.
Very good. You are
Act shall apply to every specified act.
all right.
Act shall apply to every specified state act. Let
Right.
it be applied.
Let it apply. And subject to other provisions.
And subject to other provisions of that. Let anybody show.
You show me a single provision from the act that other than specified state act, it is clearly expressly mentioned disputes can be taken.
13.
Show me 13.
Save as otherwise expressly provided in this act.
Save as expressly provided, which means specified state act.
Which also means school disputes.
Yes. Yes. No doubt.
So, save as specifically provided under this act means that all specified act will be applicable.
Right.
Right?
And the school disputes.
And the school disputes.
Now you show.
No. Kindly don't again include only. All save as otherwise expressly provided in this act. Therefore, all specified act and their school disputes will be applicable.
Correct.
The commission shall have jurisdiction to adjudicate a school dispute and make order to a person directing redressal of the school dispute. Then 2. In particular and without prejudice to the generality of the provisions. What more? Of subsection 1. The commission shall, in adjudicating school disputes, have jurisdiction. All this.
To declare that?
A law. Any law. Not it.
Declare a law.
Any law.
Right. To declare, which is the result of adjudication. First, the tribunal must receive, must entertain, must allow the petition to be on board.
That's why the first line, save as expressly provided. 13, first line, save as expressly provided.
Precisely, it is again against you.
No.
Save as expressly
12
provided.
never divorce or exclude other schools.
So expressly provided. So 12 has expressly provided. State
12 has expressly provided and school disputes also expressly provided.
I admit, sir. School disputes covered under those specified acts, which means
again you are reading.
The schools.
Again you are reading only.
The schools which are covered under those acts.
Where is that da?
Their dispute.
Where is that da? There da is not there. Then proviso in section 2, if a law includes specified act.
No. What does it say, sir? Have jurisdiction to declare that
A law,
a law or an instrument, statutory or otherwise, or an act, or shall be such effect or of no such effect.
is there
It
an
is the adjudication.
right adjudication?
So adjudication on what? Unless you receive the petition,
Lad,
unless you receive the complaint,
right. Now, lad, this
this
A
will not even apply.
this A law,
I have no dispute with this adjudication part.
lad,
I
this
have only clear my mind, the cloud in my mind with regard to the admissibility of the proceeding on the board,
whether any other private student dispute
which are not governed by those 7 acts, come
be-
within the
can be
purview of trial.
adjudicated by this commission or not.
Yes.
Now, lad, nowhere it has excluded. Rather, section 13(2) proviso, while 13(2) subclause 1 says a law or instrument, proviso specifically mentioned specified state act. Proviso clarify. Then what is if a law, if means only a specified state act, then what is the requirement of this proviso?
Provides,
A law must not
provides that where the matter relates to disposal of question of constitutional validity of any provision of any specified state act, kindly read it. The matter shall be decided by the bench, constituted, and blah blah blah.
And what is about and what about the law? Again, what about the law? Clause 1, a law or instrument. What are those laws?
Those laws in the light of those specified act.
In the light of where from your is getting? I
Reading.
Generality of provisions.
This is the generality of the provision.
This is no, cannot be. You cannot entry at the
Then,
13
Malad,
unless you cross 12.
then Malad, these provisions will be Malad, redundant.
No,
Odious.
not redundant at all. This act is meant specifically for those 7 acts. Tribunal or commission is created specifically for those 7 acts. Where is the bar? Then you have to challenge this act only. That if you restrict this act, then my right is restricted. That may be a point. That you go for challenge. I don't mind. But unless that is there, so long you accept this act, you cannot go beyond that.
Malad,
you can challenge the act. That is up to your.
But my case is that acts includes me. Because kindly for the time being,
Very well.
for the
Then-
time being,
Then
kindly assume section 12 is not there.
yes, you are absolutely in. You are absolutely in by virtue of the definition of school dispute. Erase section 12, I don't mind.
Now, Malad,
Since you are saying,
how do you
you are rightly saying that I cannot, the court cannot.
to
put
understand
words.
Malad, whether I'm incorrect or I'm correct or not, Malad, may I Malad, clarify this part, Malad? What is the meaning of the second line? By notification appoint, which is not there in section 13, not 11, not 10, or any other section.
Appointment of the act. The act.
Now, Malad,
You see any preamble of any act,
Malad 2G.
you will find this
Kindly
same
see,
expression.
Malad 2G.
2G.
2G. 2G in this act. What is the requirement first? What is the requirement of this definition to be included in this act?
Notification 2G is the notification, means a notification published in the official gazette.
Right. Then first query is why the definition notification has been included. To understand the notification meaning for the purpose of interpretation of this act. Am I clear?
Yes.
Now kindly takes up 12.
Unless this notification is there, the act would not have come into force.
To understand Now, kindly see this, the legislature did not pass this bill.
Pass this
Bill, this act. Bill is placed with the definition notification. What is the requirement to include notification? Because everybody knows under the law.
Is it your case that this part has not come into force?
Entire act has not come into force.
That is your case.
Must be.
Argue on that. Argue on that. I don't mind.
Act has come into force. I'm sorry.
Sir, Mr. Ahmed, if you argue that the entire act is not come into force, so don't look at the act. Simply don't look at it. I will take your argument as it is, then I will find out whether the act is into force or not.
Right.
Right? But if the act is in force, you are hit by 12. Then you are hit by 12.
No, I'll explain to Rashid.
No. First, then choose your stand and argue accordingly.
Let from this act, first section 2.
Because so long you have argued, 12 is not a bar for your case. Correct? Now you are saying the act is not there. If the act is not there, no 12 is there.
My case is just in 2 sentences I clarify. My case is act has been promulgated, but it has not been given effect to. Why? Because of section 1(2), which says the act will come into force from the date of appointment. It may be on the date of appointment they also constitute the commission. Maybe, may not be.
Which admittedly they have not done.
So act has been promulgated, but effect has not been given. This is my case. It's very clear. Because
so, therefore you say that act will not apply to you.
No, I mean, I have never said that.
If the act
until it is given effect to, no, it is applied to nobody.
That's precisely I'm saying.
Yes.
So you argue on that point that the act is no more there, not
the
even
act
there.
Is there.
Promulgation is there, effect is not there.
Effect is not.
You argue that.
That is my point from the beginning. And
very well. So you don't have to argue 12 whether it's a bar or not.
No, I have to argue. Again, then I have to argue.
If you argue 12 is a bar, then you are accepting the act is affected. Mr. Ahmed.
For the purpose of interpreting.
No. Mr. Ahmed, choose your path. Choose your path. This is too high an expectation. Choose your path. Either you say act is not affected and not covered by this act because this act has not been affected. Fine. 12 has got no application. Or you say act is affected, 12 is not applied. Choose one path. You cannot choose both paths. Choose one path, make an effort.
Namlat, first, my case is very clear.
And
that
you find your notes.
Act has not been given effect to.
Not affected. Very well. You will have to file your notes.
Now, in counter they may submit, had it been not given effect to, what would be my remedy? That they may argue. If they argue that, I'll respond to it. I'm not wasting your time.
Sir, if you say act has not been affected, just sit down. They will argue. Act is not affected, you said. So you have got nothing to do with this act.
Because I am making this submission.
I'm coming. The second hurdle will be more serious for you. The moment you say act is not affected, St. Mary's will come in.
And that's why I'm saying that act has been promulgated.
So why? Promulgation and effect are two different.
Promulgation.
Choose the path.
Promulgation means the state legislatures, who are the representative of the people, they recognize that public law element is involved. And immediately they recognize.
It's not affected. How involvement, not involvement, how will it arise? If the act is not affected, let it be in the showcase. When it will be affected, public law element under that act will come to question. Let it be on showcase. It's not affected.
And one is recognition of my right, and other is enforcement of my right.
Sir, you want to enforce your right.
I want to first I have right, then I can enforce.
Right? So all along your point that I am entitled to get enforcement under this act becomes nullity. The moment you say act is not effected, becomes nullity. No argument. So long you have argued, it's all in vain.
Possibly no. Possibly no. Let first
you have to choose one path that yes, this act is in force, act is effected, I am covered under this act. 12 is no bar. 1 point. Or you have to say act is not effected, I'm not covered by this act, I have my independent right to maintain this writ petition. Then you will have to cross the hurdle of St.
In civil court, while we institute money suit,
yes,
there is a limitation of 3 years.
Yes.
If 3 years covers then there is a bar to institute, dates remain, but I can recover my money. I can't recover my money.
Relief is barred.
Relief is barred.
Right is there.
Right is there.
That's right.
Now that's what.
That's why the elementary principle. The debtor has to, the lender has to travel beyond the borrower.
Now I'll take up St. Mary. What St. Mary says.
No. First you choose your argument, sir. Choose your argument, sir. First. You first say in a simple one whether you stand to your argument that this act is not effected. Therefore, you are not even bothered to look into that. You don't look into that. I don't mind. Proceed in your way on St. Mary's and public law element. Or you choose the path, act is effected. I agree that act binds me. I have a remedy under the act. I have an enforceable right under the act. But 12 is not. Choose your path. Choose your path. You come on the next day, I don't mind. Choose your path. And you come with a note, written note.
I can file written notes.
No. You come with a note. I must get your client stand on black and white.
The state by the report says that act has promulgated.
Mr. Counsel, sir, again I say.
I must clear my stand.
Yes. If you take one path, you must clear it on your written notes.
Or that I don't agree with the lordship's subject to lordship's corrections, that my submission is act recognizes my right.
Which means act is effective.
Act is promulgated, not effective.
So then how will you get benefit of that?
Immediately it promulgates, it recognizes my right.
It recognizes your right.
Right.
Without even giving effect to. If the act is not notified at all.
I cannot enforce my right under the act.
Directive principles of
but
better you
but there are provisions under the
you do, Mr. Counsel, not a problem. You come in January with the written notes.
Like there is a directive principle state policy under the constitution.
Oh yes, of course.
They are not enforceable.
Absolute part 3.
Part 3
cannot be.
Cannot be enforceable.
Cannot be.
But it recognizes my rights.
Yes, of course.
That's my submission.
If that's precisely now comes the question. The state have a right to promulgate a statute.
Right.
The state have a right not to enforce or to enforce the right as the act.
But the right is recognized.
Right? Now, if the act is promulgated, kept in the file without any notification of effect, what will happen?
Effect.
Yes. What will happen?
Happen is
it's in the drawer of the chief secretary. Then what will happen?
No, it has been notified. So it is made public.
Even then, according to you, according to me, it is effected.
Not effected.
I'm saying according to me, according to the petitioner, it is effected with the notification published in Gazette. You say it is not sufficient effect, further notification is required or appointed day. So where is the use? You're recognizing your right under the act.
Last sentence. Last sentence. immediately it is gazetted. It says that public law element is involved in respect of all school teachers and non-teaching staffs.
At least that is the under which statute?
At least that is the legislative policy of the legislative policy of the state.
200%. Under which statute? You are arguing on a statute
Of it.
2008, but you yourself is saying 2008 is not effective.
Enforced. Recognized, not enforced.
If it is not enforced for next 30 years,
Next 50 years.
yes. So part 3 can be enforced by you for writ court, acknowledging your right under an unenforced right.
In few judgments, Supreme Court says so.
Yeah.
In 370, Supreme Court says it's
No. 370 is on a different principle, sir. 370 itself is a codified principle for a particular territory. So don't. It has got nothing to do with your case. It's a codified article for a particular territory.
if it recognizes, then
If it is, suppose the constitution had not given effect to 370 since beginning till today.
last sentence I could not
Still,
complete.
still right.
I could not complete last
God.
sentence. That I'm really grateful to Lakshmana for patience.
Come when, come, tell me when.
After it is any day.
You give me a day, both of you come with the written notes. Let me see.
Election.
Ashun.
Election January শেষে
Mr. Shamim Ahmed.
আজকে তো হয় কি বল Lordship is not in this side, that's why.
Two, three, and 4. Second week, not the third week. Subject to or
ক্যালেন্ডার এখনো আসেনি
17 থেকে কিছু ছুটি ফুটি দেখাচ্ছে
ঠিক আছে ক্যালেন্ডার এখনো আসেনি চাপতে পারছি না কিছু করেছিলাম রেজিস্টারটা ক্যালেন্ডারটা না
And what is your judgment?
compile it.
Whatever statute.
সব করে একটা স্পেস হয়ে গেছিল
মক্কেলে তো পছন্দ
This gives us chance to explain in our way. Patient hearing that I'm very really grateful.
great.
Item number 16, my lord, I am for the petitioner. Now, this matter, lordship sent to the Commissioner of School Education to revisit the grievance of the petitioners. My lord, hearing was taken, but same order was passed, which initial stage the order passed. I filed objection. Last occasion, your lordships directed me to file a short note indicating under what government orders the petitioner is entitled.
Pursuant to my lord's earlier exception, now the
Report.
exception, now last occasion, the matter when matter came up for hearing, my lord's queries was that whether fixation is right or wrong, kindly consult with the state authorities, and if it is found that is not, that's consequentially, my lord. Now thereafter, my lord, I sought for clarification. I'm not the Commissioner of School Education, my lord, in a written instruction, my lord, they made a communication that this how the pay has been fixed in favor of the petitioner, my lord, according to the government circular, my lord, he is entitled to get the 2 increments that has already been granted in his favor. So, my lord, that is my submission, my lord. After my learned senior friend submission, my lord, I shall show how and when that was.
Oh, that was the submission, my lord, earlier. Same submission. No. Report received. File I've no. 3 increments was cut after my retirement. My lord, if your lordship, my lord, your lordship directed me to file, kindly go through this. May I read, lordship? Under the following government orders, the petitioner is entitled to get 3 increments which he enjoyed, kindly mark, lordship, enjoyed during his service period, but after his retirement, the respondents deducted the same from his retirement benefits, and on the basis of the order dated such as such passed by this honorable court, the respondent paid the said deducted amount to the petitioner without preferring any appeal, and accordingly the said order reached its finality. And as such, the respondents are duty bound to refix the pay of the petitioner by issuing fresh PPO. This is the order. Appeal was not preferred. Then, my lord, I have elaborated my 3 increments. My lord, they have stated in their, my lord, report that 3 increments has been curtailed. 4B. 4. 3 increment I will entitle. They are in writ petition. But a writ of under order in the nature of mandamus commanding the respondents, their officers, men and agent, and each of them to refix the pay scale, including the basic pay of pension of the petitioner by following the special government orders, and to release the entire determined amount to the petitioner.
Kindly see, the I sought for clarification. No, Malad, he is entitled to Malad only one thing, Malad, the Rupa under Rupa 1981. Malad. Yes, Malad, that was stated. Now, Malad, this clarification, Malad, that is elaborately stated. Malad, I am handing over this copy also, Malad, my learned friend. Yes, yes.
Mohammad Salahuddin. Three increments. On 10 years, 20 years, and Rupa 198. 30 rupees, 80 rupees, 100 rupees.
10 years benefit, 20 years benefit, and
98.
So the student number you can.
Malad, 1, 2, and 4.
Student number 1, 2, and 4. January 2024, January 20.
Orders. কিছু আছে again they have come the 84 years old. Last affidavit, his son came, who is also a lordship. Mischief done in 1983. And there in report they have a sum of rupees such and such was deducted. Moment order is clear. I have submitted your lordship. That is GO number 4083 EDN B.
Geo number 408, small, dated September 30, 1980. And
In modification of clause 2 of para 3 of GO number 4926 main. GO number 372 EDN. GO number 244 EDN B 87. Next page. Okay, 492. I have already stated. Then
44.
GO number.
Dated August 20, 1987.
GO number 25. And ROPA 1998 number 155 AC.
Number 155-S, dated July 1999, and is submitted by memo number 25-.
That was already stated.
Dated shall also annex
But I have also. Well, how they are now saying that they have already paid, but in report they have said from the return benefits of the petitioners are overdone amount cutting 3 increments. They have said. Now they are saying all have paid. It is in report of their.
By mistake, the 3 increments were granted in favor of the petitioner. Now, since that after retirement, that was this by taking all this.
And that.
Whether the petitioner was entitled to all 3 increments, and if not, the reason for the same.
And according to the order passed by the Honorable Court in 2010, they are duty bound. Already repaid the money with interest and cost also.
The issue of the refund, overall amount refunded since that was deducted after the return.
So how?
Now for the subsequent benefit, the refixation is not a part. That is easy. Grateful Lordship. Respond.
Chapter 7. Course. I am for the petitioner.
And for the private respondent number 6.
So the petitioner's son was a school teacher in physics. He passed honors in physics from Narendrapur Ramakrishna Mission, then complete MA from University of Calcutta. Appointed in the year 1990 as a physics teacher near the school of Diamond Harbour. Yes. He has died in the year 2015, and police has started a case under sections 306 against the wife. Charge sheet has been filed just now. 306, this is Abetment Commission of Murder, suicide. Lordship, kindly see. Yes. Lordship, son are staying in the Diamond Harbour and wife in a service at near Ranaghat in a BDO office, staying there. On 13th, the mother, your petitioner, that is mother. Yes. No, sir, I'm coming. The police has started a case under section 306. The commission, Abetment Commissions to suicide against the wife, has been started. Yes. The Lordship, I have come. Lordship knows the according to Hindu Succession Act. My fear is the benefit after death from the school should not be transferred to the wife. Why? According to section 25 and 27 of the Hindu Succession Act, when there is abandonment of murder, this should not entitle for Lordship. Kindly see that section 20. Yes, Lordship, the 25 of the Succession Act I am reading. A person who commits murder or avails the commissions of murder shall be disqualified from the inherent the property of the persons. No, yet not. No, so as the matter is pending, so nobody will get the benefit. Otherwise, yes.
I'm representing the wife. Yes, my lord. My lord, first of all, the case was started under section 306, which is abetment of suicide. My lord, section 25 and 27 of the Succession Act talks about murder. My lord, murder and suicide are two distinct offences. They are different from each other. And my lord, I have...
That is the Bombay High Court has cleared it, Lordship. This is the motion stage, Lordship. They directed to file a affidavit.
My lord, I haven't yet.
There is that is direction. Lordship, before that, may I start? Just one second, Lordship. There is a direction to file a affidavit. They have not. Lordship,
The direction was on the
my
state.
is to if they Lordship, nobody will get the money. Otherwise, if they get the get yes, get full.
Who shall calculate everything and who shall take charge of the?
I think DI.
According to CRB rule, all of the nominees entitled to get. Now, instead of the nominee, the headmaster is the custodian of papers regarding the nominee. The DS
party.
No, school is not party. One second, my lord. Commissioner school, director of education. Yes, the headmaster is the party. That's one number 5. That's one number 5.
only one thing and comes the prayer of the prayer is that they treated the petitioner as a nominee instead of the bride. So that the report is no. The nominee is the wife, but the mother is saying they treat him as a nominee.
The Supreme Court and
Mr. Money must come before shall be deposited in the database.
I'm grateful.
The money must come out of the deal.
I am grateful.
Then on affidavit, everything is there.
I am-
Must protect the and secure the money.
I am grateful.
Yeah, instrument number.
DI is 4. This one number 4.
Some school teacher died on
15/7/2020.
No.
2020.
9/20.
No, that's it.
Yes. It's in your affidavit.
My ex-service.
Yes, 15th July.
My mistake saying no document regarding on the that you can
Listen. It may lead to the repetition. Mother they release and reimbursement of all the employees profit fund. Has been so we now have the motion that is the concept appears for respondent numbers
1,
124. Yes.
My Lord Rajnandini Das, I'm led by Mr. Shovik Mitter.
Advocate.
For the respondent number 6. Yes, my Lord. Yes, my Lord.
Led by Mr. Shobhit. And the concept appear for respondent number
6.
is the of and the government law of protection.
Ranagat. So kindly come to the page.
Page 16, my lord.
Was 13 also, and page 16. এটা তো FIR. Lordship kindly go page 13. And
on the basis of a complaint lodged by the petitioner mother,
petition.
the police authority has registered a criminal case against the video of the deceased government state employee. Particularly under section
306
and
slash 34.
306 stroke
34. My lord, apart from the respondent number 6, there are other family members of the respondent number 6 who have also been implicated. Yes, my lord.
The trial judge issued.
Charge sheet submitted.
Charge sheet submitted. The trial is in. Mr. Vidal, the motion and state council submits that in the service record, the name of the nominee.
My submission, my lord, on instruction I am submitting, the school authority did not forwarded any document or
What is the name of the nominee?
Lord, that is not the Lord, all the my respective submission, my lord.
Submits on instruction that the school authority that is responded number
School headmaster is respondent of 5.
has not forwarded his documented record at the office of the respondent number
4.
4. Yeah. 4 the of the jurisdiction and district records.
For the purpose of family pension, gratuity and
For the purpose of taking steps process the employment benefit of the system. Considering the above, respondent number
School 5.
5. Not represented. Considering the above, the petitioner shall serve a notice along with a copy of the case order upon the respondent number 5 and shall file an affidavit of service with the matter shall be taken up. But the respondent number 5 is mandatorily directed produce a cluster all records because documents relating to the son of Ishma was the employee of the school. Before the respondent number 4 positive period of weeks date of communication officer. Upon receiving such records from the school authority, the respondent number 4 shall calculate and prepare the accounts in respect of all the employment benefits able to be payable on account of the business sum of the petitioner was the school teacher. In accordance with the responding number 4 shall carry out and complete this exercise positively remains from the date of receiving the records and papers from the school authority of the responding number 4 paragraph. Then, after completion of the calculation, shall file a report in the form of affidavit on this form, disclosing total employment benefit able to be deceased teacher in accordance with every such affidavit shall be filed on or before the director 3 weeks.
3 to 5.
By February 2024. Upon receiving such report, the court may proceed to consider again the respondent number and any other appropriate authority of the state. Deposit card payable teacher in terms of the same calculation. Running this general of the school. Subject to other building. The petition shall appear on the beginning parts. On February 20. So, make sure that directions made herein are mandatory for all the respective parties.
Grateful, my lord.
Also, just one thing, Roshi. If not matter is appeared or determination is changed, so logically protect that part also.
Grateful, my lord.
Grateful, Roshi. I am grateful.
My lord, I am for the petitioner. My lord, Mr. Shondipan Pal is appearing on behalf of the petitioner.
My lord, I am appearing for the petitioner. Brief this matter, my lord, is appealing from 2017. But I have appeared several times, my lord, before different courts, my lord. None appears for the respondents. For the petition. Sorry. Respond. I'm sorry. This probably, my lord, weak, terribly weak, because it was malignant malady. That is very difficult, my lord. My doctor advised for some rest. Respondent numbers, my lord. Huh? 1, 2, 3. 1, 2, 3. কোথায়? কি রে? My lord, it will be 1 and 2. 1 and deeply.
Your Lordship, in item number 27, I am appearing on behalf of the petitioner. Your Lordship, on the last occasion, uh, Your Lordship appointed Mr. Bhaskar Boisho, learned additional government pleader for representing the state, and Mr. Abhishek Prasad. I serve the writ petition. Your Lordship, this is the affidavit of service, Your Lordship. Your Lordship, this is the matter. This is the matter, Your Lordship, whereas the petitioner is a headmaster. He retired from his service in the year 2015. Till date, neither disciplinary proceedings nor any criminal proceeding, no such proceeding pending. But his superannuation benefit has not been yet released.
Malot, this.
Your Lordship.
Malot, here what happened? Here, Malot, the material respondent, I would say, because this case is having a checkered history. In one occasion, there is a direction for CBI inquiry also here. Now, what happened, Malot? The managing committee of the concerned school, Malot, they have initiated a. Now,
And another issue, my lord, provisional pension, what I have seen from the record itself, provisional pension was started because they were going to, yes,
Provisional pension is being paid in terms of virtue of this honorable court's order. Yes, your lordship.
Yes.
But only one thing, yes. But 19 subclause 5 note of the DCRB scheme, it says not if there is any pending proceeding, then not final payments cannot be made. So there is a may. Now, lot of deposit is only to secure. Secure against whom? My lord kindly sees. Not a private individual, it's the state. It is against the state. So it is already secured. And in the state. No, not me. No, it is for the state. It is my duty, my lord, I have discharged. My duty, I have discharged. My instructions are that yesterday, my lord, it has been sent. But kindly do not record that because my learned advocate record until
yes. And my lord, the provident fund, he received the provident fund also. Provident fund gadget. Admissible. And that should be, my lord, the school authority should do the needful in the.
The state to furnish security. No, it is for the state. That is what I'm saying. No, I have nothing. Look, kindly see, kindly make it clear. It is for the state. Let the state say. They will not deny. We are only to not forward it. After that, fine.
My lord, one prayer just I am making, my lord, in that my lord, because we just got the brief as per your lordship direction. If my lord, if the first week of
Your lordship. In the year 2015, I just your lordship. 11th, 6th May, 16th May, your lordship, 2015. Your lordship, pardon me, 31st July. 31st July 2015. 31st July 2015. 31st July, your lordship.
Additional pension and by virtue of the direction made by Congress means taken.
Your lordship, the order dated passed by Justice Subroto Talukdar.
Okay. 18th September 2017.
September 18, 2017. The petitioner contains that no disciplinary proceeding has ever been initiated or been pending against the petitioner.
Is pending.
Your lordship, no criminal proceeding has been till initiated. The facts-finding committee forwarded report to the anti.
It's that no criminal proceeding has been initiated.
The Honorable Court directed the CBI to inquire in terms of this Honorable
Yes.
Court's order the proceeding initially.
Respondent number 5 to 9.
5 to 9.
Submits that has been initiated and discussed.
Your lordship, the CBI has been added as the party as a respondent to initiate the proceedings against the by virtue of the, but CBI prefer an appeal, and appeal is pending.
It has also been preferred by CBI, which is great.
Your Lordship, the learned advocate for CBI is.
Mr. Abhishek Prashant, the State Council refers to respondent numbers.
1 to 4.
Ms. Chandri, the council refers to respondent numbers.
Lordship, we're not impleaded in the petition, Lord, CP.
For the second period of investigation.
Lordship, there was an appeal that, I mean, it's nothing effective has happened according to my instructions, but there have been.
CBI also something that merely
An appeal has been filed, yes.
and no further development. Considering the solutions made on behalf of the parties. The respondent number, which is only your hand, is
5 to 9. Documents have been sent. In terms of my lord's last order, we were to forward a no liability certificate. That is all that is required for the state to process. So that has been sent. Now have instructions. May I hand up a copy, Milord? Yes. This is not the document.
The last one,
Respondent 5 to 9. No objection.
To whom? A copy of the
Now, my lord, the only thing, my lord, the copy that has been handed over to your lordship, my lord, it is not showing any receipt. How the mode, how it has been given to them, because it was sent to the DPPG, but it has to be routed through the DI of school.
Commissioner.
Commissioner, respond number 6.
on permission of the state document is commission and the state council service back. Of the same document, it is not clear to me. Yeah, the required papers and documents are submitted on. In view of this, the respondent number 4 and respondent number 6. The respondent number 6 shall visit the office of the respondent number 4.
There is no denial as such. He is only suspecting.
Because it
No, this has been sent. Kindly, this I'm an officer of court. I'm assuring that this has been sent. If they have anything to say, seek a clarification. They can seek. No.
Considering these submissions, the respondent number 4.
Yes.
On before, as you call the 50. December 19, 2023. Write the letter to the respondent number 4.
6.
Mentioning the necessary and required documents and records.
If any.
Required to be produced before the respondent number 4, if not already produced by the respondent number 6. And upon receiving such letter, the respondent number 6 positively within a period of 3 days from receipt of such letter shall either produce all the records and documents required to be produced before the respondent number 4, or in writing shall clarify its stand. If no further record or document is used by the respondent number 6. The respondent number 4 thereafter positively after carrying out this exercise the document mentioned above in a period of 2 weeks shall carry out all the necessary exercise ascertain admissible amount payable to the commissioner
এটা তো acted upon হয়নি প্রফেশনাল পেনশন হিল
in accordance with law.
This is a PPO issue.
বলতে পারছি
Computations have already been done. PPO has been issued. So now they only required to carry out my lord's order of securing the amount. Kindly see this. In terms of this, the provisional pension was issued. This is a PPO. My learned friend Miller possibly is not abreast with the facts. But in terms of the order passed by maybe this is R3, not P3. In our report, my lord, we filed this. Lord, I filed, my lord, the report in terms of my lord's order. My lord would find it, my lord, separately apart from the paper book. And this, my lord, forms. Yes. But this is of the PPO.
Let it be there.
No. I am not saying. I am saying, Lord, my lord is undertaking a detailed exercise. Yes.
My order was of December.
My lord's order was requiring me to give a no objection certificate so that the computation. May I complete? May I only complete? Lord, I am assisting your lordships. Lord, a computation was done. In terms of this computation, provisional pension was issued. So the state is aware as to what is he entitled to. Now, why the entire was not dispersed? Because, my lord, I had put my foot down. I said I'll not issue no objection certificate. CBI has been directed to investigate. My lord said that you issue a no objection certificate. I issued no objection certificate, my lord, which is handed over to my lord today. So now the amount is already crystallized in terms of the PPO issued, in terms whereof he is getting the provisional pension. Now no objection has also been issued by us. So what remains in computation? He is only to secure the amount as provided for in the PPO with the registrar of this court, less the amount of provisional pension paid. Where have I been able to make myself clear?
No objection, absolutely.
After considering his submission,
I really do not know how he is agreeing.
Yes. Yes.
No difficulty.
upon carrying out this exercise, the respondent number 4 has calculated total amount after taking into consideration the provision of pension being paid, which is payable to petitioner on the basis of admissibility in accordance with laws, and file a report containing disclosing the detail of such calculation before this court by way of an affidavit. Such report shall be filed on our report January 5, 2023. It's the background. Upon a copy being furnished to me, I will come report for the petition.
Also to us, my lord. Because I do not, with regard to the computations that he does, whether it is in consonance with what we have given or not.
Admissible.
10 rupees. They pay 15 rupees. How does it matter? If they pay 8 rupees, then the petitioner is challenges. How does it matter? At the end of the day, it's not your statement. Here is the site on January 9th, 2023.
What's your mission?
I'm glad.
Yeah, the last one, number 4 shall be lost.
Yes.
Amount because which is first.
No, no prejudice. Once CBI says that it is not going to inquire, I have nothing to say now. and I have carried out my lord's order. I'm grateful to you.
My lord, I'm led by Professor Bhushan Ghosh.
For the petitioner, kindly bring for note today.
For the respondent,
Sir will argue this matter.
yes.
Sir will argue in this. My senior will argue this matter. Okay.
WPA 23183. WPA 23183 of 2023. Order dated 3rd of October 23. October 23. This one I should.
Grateful.
I'm for the petitioner. No, Mala, I'm for the petitioner. Every service, Mala. MSK 65. Three, Mala, code fee. Yes. Aniruddha Bhattacharya. Great.
Item number 65. 65 to 73, my lordship, not today. Bashobi Raichudhuri.
Hearing has
Central School Service. একটা স্টেপে লিখে দিলাম।
But happy for the petition. My lord, pursuant to my lord last direction, my lord, I have served notice upon Mr. Suman De, my lord, who is appearing for the state, my lord. But here, my lord, the petitioner participated in the selection process. No, my lord, 9th RLST. 16 na. 9th regional level selection set conducted by the West Bengal Central School Service Commission, my lord, as a physically handicapped category candidate, my lord. Petitioner was called for, my lord, my lord,
Well, 130. 136. Well, it can be disposed of if the judgment has been delivered. In view of the judgment, the petitioner's guest teacher matter. Guest teacher matter. The Lord says, in view of the judgment, matter may be disposed of. The judgment I have. Not dismissed because the certain guidelines was given. There are 43. No order can be passed. এটা দিয়ে দিন। হ্যাঁ তুমি নাই
না ঠিক আছে।
Last paragraph, certain parameters have been prescribed. যেটা বলছে কেন মমতা সাহেব যেটা his appointment was after 1st April 2000. The enhancement of the remunerations, page 29. That was the claim, but while in view of the judgment, I am not interested. Enhancement of the remunerations. Oh, that is the benefit.
One of such being the first of such being the find refugees from by a judgment delivered
কত লিখে দিয়েছিল? নিশ্চয়ই দিয়েছে, কোথায় হবে?
Decided September 7, 2022. This is the appearance of the first, second, third, fourth, fifth, sixth page of the judgment. Sixth. Where the name of the advocates are appearing. Decided 7 September 2022.
September 7, open Mr. Pali has submitted
And
versus
yes.
Lordship, 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 item number 126, advocate on record for the item number 126, advocate on record for the petitioner. Lordship, Lordship.
আমার হবে না
139 my lord,
না,
I am for the state response.
না না ডাকেন
উঠছে আর